The legal system tells us that courts exist to correct error. That is only partly true. There comes a point where accuracy is no longer the priority. That point is called finality. Finality is the doctrine that says a case must end, not because it is correct, but because it is closed. This is not hidden. It is not a conspiracy. It is an explicit rule. After a conviction, the system allows review only for a limited time, through limited procedures, under increasingly narrow standards. Miss a deadline, fail to raise an issue the right way, rely on counsel who does not preserve the claim, and the door closes, not because the conviction is sound, but because reopening it would disturb finality. At that point, the question is no longer what happened or even was the Constitution violated. The question becomes, is the system willing to look again? And often the answer is no. Finality values closure over accuracy, stability over truth, efficiency over correction. That is how a conviction can survive even when the underlying process was flawed. Which brings us to the question, answer it as a hypothetical. Assume clean facts. No slogans. If a conviction stands only because the door was closed, is that justice preserved or error protected? Defend your answer. That is 90-second law.